Good morning. This is the opening session of the Kansas Court of Appeals. Today, we are also on YouTube. So those of you who have never appeared on YouTube, this will be your first experience to become a movie star, so to speak. This panel this morning includes Judge Sarah Warner, who joined our court in 2019, and also Judge Leslie Ann Isherwood, who joined our court this year, and myself, Kim Schroeder. I will be presiding as the presiding judge, so to speak, and my main responsibility will be to watch time for each of the individual arguments. I'm not a real strict timekeeper, but we will try to keep it somewhat on time. This case is set for 20 minutes on each side. It is Mid-Continent Anesthesiologist Chartered versus Gerald Bassell, or Doctors Gerald Bassell and Dr. Robert McKay. It is case number 122-277. Counsel, if you would, for my benefit, would you announce your appearances?
To please the court, my name is Jack McIntyre, and I'm with the DePuy Gillen Law Firm in Wichita, Kansas, and we represent Mid-Continent Anesthesiology Chartered, generally referred to as MCAC.
Your Honor, this is Jay Fowler, Folsom Seafood in Wichita. I represent Gerard Bassell, MD.
Judge, this is John Gibson, Gibson Watson Marino in Wichita, and we represent Dr. McKay.
Thank you. This matter is set for 20 minutes. So how do the the appellants plan to split their argument?
Your Honor, Mr. Gibson and I have conferred, and our general plan is that I will take about 12 minutes. Mr. Gibson will take about 5 minutes, and we would like to reserve 3 minutes for rebuttal.
And is that for one or both of you?
Just one. I mean, that's for the entire 20 minutes. Yes, sir.
Okay. Well, if there's nothing else, I think we're ready to proceed with the argument. I would just remind counsel that with us being on video, that sometimes you might see us looking away. That doesn't mean we're not paying attention. It just means that we have multiple screens that we may be looking at with notes and issues that we have involving this case. So with that, Mr. Fowler, I think you're up first, so you may proceed.
Thank you, Your Honor. May it please the court. This lawsuit is based on a false premise that all of the physician employees were entitled to the same or substantially the same pay. As a matter of background, it's not a breach of fiduciary duty for different people in the corporation who perform different roles to be paid different amounts, and a difference in pay does not equal damages. In this case, and this is important when we get to the statute of limitations issue, Dr. George at MCAC's accounting witness calculated damages based on the notion that all of the physician employees of MCAC who were also shareholders were entitled to the same compensation as someone who had been there for 30 years. But there is nothing in the record, there's no agreement, no guideline, no requirement that supports MCAC's theory that all physicians must be paid substantially the same. And this is an important factor. Dr. Babish testified, as did the other physician employees who were also shareholders, that they knew that Dr. Bassell made more, that Dr. Bassell hired, for example, Dr. Babish, telling her that he was going to make more because of his role as the CEO. So all of the physicians knew that Dr. Bassell made more. CEOs normally make more, they do different things. And in this case, a shareholder is not a partner, and all of the people involved in the company were paid as employees. So with that background, how did this case get off track? Well, the court accepted the notion that if Dr. Bassell got $100 more in compensation, there could be a claim. And then, and this is the heart of the appeal, there was a fundamental misunderstanding by the trial court on the application of the statute of limitations. Two things happened. First, the court decided that there had to be absolute actual knowledge by all the non-culpable directors to start the running of a limitations period. He actually went so far to rule that no cause of action could accrue until there was a completion of a process, which is not really heard of in the law, of a weighing of verified facts. And he ruled that verified fact testing process could take weeks or months. But then secondly, that it got off track because the trial court ignored the entire notion of corporate knowledge as relevant to the statute of limitations and failed to properly assess the meaning of reasonably ascertainable that we find in KSA 6513D. He went so far as to say that it's my position that you can't accrue the cause of action until the investigation is reasonably completed. And when the investigation is completed.
Counsel, when we say reasonably completed, what is that test? Is it an objective test? Is it an objective/subjective test?
Well, there's no reasonably completed test in the context of the case law limitations. It's reasonably ascertainable, and it is an objective test.
It is an objective test.
Yes, yes. And that's the problem. Judge Comer applied a subjective standard for corporate knowledge that ignored the information available that Dr. Babish and the other physician shareholders knew that Dr. Bassell was paid more, knew full well of their issues regarding the vacation, and that all of the facts were accurately recorded on the books and records of the company. So, I mean, that's really the important. And
if it is an objective test, then it strikes me that is a decision that should be made by the court. Why should this issue then go to the jury?
It should not. It absolutely should not. What Judge Comer did is he read the Chtd case, and he decided that the Chtd case was a case on a referral of a question of law from federal court to decide whether the adverse domination theory ought to apply in a claim by a corporation against a director. And the case said that a majority of non-culpable directors would be the approach that the Kansas law should take. Judge Comer decided that meant a majority of non-culpable directors had to have actual knowledge to start the running of the statute of limitations. That's not what the Chtd case said at all. But we don't even need to get into the semantics or the meaning of Chtd, because after Chtd was decided, the legislature readopted KSA 6513D and defined the rule. And it says there must be an act that causes a substantial injury, and there must be a disinterested majority of non-culpable directors. It only requires that a disinterested majority exists, not that the directors have actual knowledge. There is.
And counsel, who makes that determination? Whether there is a disinterested majority of directors who are now involved in the organization?
Well, in this case, it was very clear that of all the shareholders and all of the directors, depending on who's the director, when and where, it was very clear who, and it's non-culpable, really. It shouldn't say disinterested, it should say non-culpable. The non-culpable directors were the 6 other physician shareholders, and there was never any dispute about that.
And just so I know, in terms of figuring out the time frame, like when you have that disinterested majority, is that a question of fact, or is that somehow a legal determination that the court would have to make?
Well, I think in this case, based on it's not a question of fact, because there wasn't any fact controversy about that issue, about who the culpable people were under the claim and who the non-culpable people were claiming. In fact, if you go look at the record and the briefing, those questions were specifically asked, and they're part of the record. Was so-and-so part of the conspiracy? Was so-and-so?
Well, and it's my understanding, however, that the court concluded that there was at least a question of fact, and in fact, the court found against you in terms of resolving this question of fact, but found that there was a question as to when those non-culpable employees, shareholders, whatever you want to call them, became directors. Is that accurate?
Well,
Let me interrupt just a minute. My video no longer has Mr. McIntyre. Has he been dropped off?
my video doesn't have him either.
He's in the waiting room. I'll bring him back in.
Oh,
Counsel,
I apologize. I don't know if anybody else was cut off, but I certainly was, and I do apologize for that.
well, my question is I don't know that what do you recall at what point you were cut off?
With Judge Warner and Jay were talking about the objectivity of the standard.
All right. Do you want us to start the argument over or just continue with that question?
I think we'd be better with we just continued. I appreciate the consideration. I apologize. We apparently lost all internet here for just a brief second.
Well, that's just one of the issues.
And so I apologize.
Well, it's out of our control having to do processes in this way. So we'll try to accommodate. So Judge Warner, if you'd rephrase your question and then we'll let Mr. Fowler proceed.
Certainly. My question, counsel, was it appeared from my review of the record that the district court found that there was at least a factual question as to when these shareholders, these non-culpable shareholders became directors. And it, in fact, found that at least resolved that factual question against you. Is that accurate?
Well, it's a bit perplexing because the testimony and the uncontroverted facts presented at the time of summary judgment was that all of the shareholders were directors as of February 16, and that there was a majority of non-culpable directors as of December of 2015. That was an admitted fact for the purposes of the case. At some point, Judge Comer decided that maybe you had to have certain formalities to have existed, and that maybe those formalities didn't exist until later. And then he applied this rule, which wasn't even argued by MCAC initially in the case or even through the first part of the trial. All of the physician shareholders testified and agreed that as of February 16, 2016, they were directors of the company. And so it really wasn't a proper fact dispute at all. Of course, if it was a fact dispute, he shouldn't have granted summary judgment, but that's a separate issue. And so what we have, and there's, the record goes on that these folks were also directors before that time. They received director's pay and all of that, but there's some ambiguity out there, I suppose. And so we've simply taken the position that we know as of December of 2015, and certainly as of February of 2016, there was a majority of directors they identified as non-culpable, and that is the standard set forth in 513D. So that's what we know, and that's really not a point of controversy in the case. And that's where this case fell flat on its face. The court applied a subjective standard for corporate knowledge, ignored, in our view, a legion of case law on what reasonably ascertainable means and what corporate knowledge means. What does corporate knowledge mean? Well, the Wygan case at 227 Kansas 747 we cited, the officers and directors are chargeable with knowledge of facts which the corporation books and records disclose. What does reasonably ascertainable mean? Well, the Davison case we cited, Supreme Court case 259 Kansas 659 says, it does not mean actual knowledge. It obligates the plaintiff to investigate available information sources and holds the plaintiff knowledgeable with constructive knowledge of information available through a reasonable investigation of sources that contain the facts. Those are the rules. What was the claimed injury in this case? You got paid more. When did that occur? They said it occurred 10 years earlier. The reason they picked 10 years is because you go beyond 10 years, you got a statute of repose problem. So we know that they claimed there was a substantial injury. They know they claimed it was 10 years ago. And so when was there this non-culpable majority? Well, by the way, this is pretty important. Dr. Bassell only had 1/8 of the voting power of the company. He could be outvoted 7-1 at any time in terms of new directors, corporate control, firing. Even if you put Dr. McKay in his camp, okay, now it's 75% of the other shareholders have control of this company. So we know.
Does the analysis change at all in light of this, at least factual argument that Dr. Bassell and Dr. McKay prevented the other directors from accessing those documents? That's at least a factual allegation. Does that change our analysis?
It may be a factual allegation. I mean, we deny it, they say it is. But go look at Dr. Babish's testimony. She acknowledged by 2014, she had the ability to know and was given the information. Now, later on, she goes in and changes her 5 yes or absolutely answers to no. But even if you look at those changes, and we don't think the court should give credit to those changes because there's a legion of case law that says you can't do that. But even if you gave credit to those changes, the statements made on uncontroverted facts still establish the requisite knowledge by the shareholders and the directors of what they claimed was the basis for their tort. Statute of limitations need to mean something. Now, one of the points raised by Judge Comer and perhaps by MCAC is that, well, the Kansas courts really haven't adopted a rule that you can't change your deposition testimony to avoid summary judgment by use of an errata sheet. We filed a motion to strike. We asked the court to strike that errata sheet. It doesn't make any difference on the key facts because they're all admitted. But if you go look at the Burns case in the 10th Circuit, or there's a legion of Kansas federal district court cases, they all say you can't use an errata sheet to change material facts. And if that's not the Kansas rule, it needs to be the Kansas rule because that's what they tried to do here. But even then, if you look at the record, Dr. Babish's testimony and the admissions of the other physician shareholders established the requisite knowledge to put them on notice that makes this reasonably ascertainable.
Counsel,
I need to yield to Mr.
Yeah, I was going to say, thank you. You're going to yield. Appreciate it.
Right, I'll yield to Mr. Gibson.
May it please the court, John Gibson and Andrew Marino represent Dr. McKay. On behalf of Dr. McKay, we just want to adopt Jay Fowler's arguments and not repeat those. One point is that I want to make, Dr. McKay is not claiming that the statute of limitation bars any claims against him for payment made to him after March 7 of 2016 for that short period of time. We appeal the issue of conspiracy, and just briefly, conspiracy requires, and this is the Mays versus Ridenour case, 248 Kansas 919. Conspiracy requires that there be at least 2 people. In this case, it would be Dr. McKay and Dr. Bassell had a joint objective of breaching a fiduciary duty and had a meeting of the minds that they would do so and had one or more overt acts to accomplish the objective. Our point and the reason we appealed is there simply was no evidence presented at the trial of this case, no evidence that any of those things happened and no evidence that would allow a jury to infer that those happened. So we're asking the court to grant judgment as a matter of law in favor of Dr. McKay on that issue.
Counsel, on the issue of conspiracy, can the joint acts of the 2 doctors, although maybe not verbally agreed upon, reflect a conspiracy by agreement?
Well, there was no, I'm not sure that can happen, Judge, but there was no evidence that there were any joint acts by them. There were no evidence of meetings, of memos, of correspondence, any evidence whatsoever that there was any joint acts between the 2 of them. The only thing that they presented was we have two of the principals getting paid more than the others. But that doesn't because that doesn't mean that they conspired to do that. Dr. McKay, I'm sorry, Dr. Bassell, from the get-go of this corporation was in charge of setting the salaries of all, and that's agreed. There's no dispute about that. And that continued until the time he retired. The evidence was, and the record supports that throughout this, Dr. Bassell is the one that set the salaries. There's no evidence that Dr. McKay had anything to do with that, consultation or otherwise.
All right. And Dr. Bassell had been setting the salaries of the various doctors since like 1984.
Correct. Yes.
And that had been an ongoing working relationship within this corporate hierarchy.
Correct.
All right. You may proceed. Thank you.
Jumping to the statute of limitations issue, and just briefly, from December 12 of 2015 to a couple of weeks later, December 31st of 2015, there were 5 directors, 3 of which were non-culpable. And I direct the court to Exhibit A to our brief, which the court can't read it here, but what this is, Exhibit A is the unanimous consent in writing of the board of directors of MCAC. And they say, we, the undersigned, constituting all members of the board of directors, and it goes ahead with the resolution. That is signed, it's dated December 12, 2015, and it's signed by all 5 of the directors. Dr. Bassell and Dr. McKay were 2 of those directors, and then the 3 non-culpable directors that could outvote them were Dr. Castrizos, Dr. Babish, and Dr. Manry. And their testimony was, and the record reflects, that they say, yep, we signed that, yep, we read that, we knew that we were directors at that time. These doctors are intelligent, savvy people. When they sign a document like this, they read it, they know what it says. They knew at that point on December 12 of 2015, which was a year, 2 years and a third before suit was filed, that they were directors. They could outvote the culpable directors, and they took no action. You then jump to December 31st or January 1st. At that point, Dr. Bassell is gone. He's retired. Dr. McKay then is the only culpable director. He then can be outvoted 4-1. And again, the evidence was that they knew they were directors. Whether there was a minute that said they were elected as directors. They knew they were directors and they were acting as directors. You then go from that point to what's called the Newport Grill meeting, which was in February 17th of 2016. And at that point, they elected 6 directors. And at that point, Dr. McKay was the only culpable director. There were 5 other directors, being the other doctors. They knew they had control. They knew they were directors. And again, they basically just sat on their hands. Through this period of time, Dr. Babish was the secretary treasurer. She had been given financial information even before she became secretary treasurer, beginning in 2014. She testified, and by the way, Dr. Babish not only has an MD, she has an MBA. Dr. Babish testified that she received all that information. She knew she had it. It was the information from the books and records that was provided by the secretary of the corporation. And she said that she was simply just too busy to read it. Even though she had been elected as a secretary treasurer, she had obligations as a secretary treasurer, and her obligations were to determine and know about the financial information of the corporation. But her testimony was that she was too busy to read that stuff. Her knowledge, and her knowledge is in those records, is imputed to the corporation. And it's important in this case to understand that the corporation is the plaintiff. Corporation books had all of the information. There's no dispute in the case that all payments to Dr. McKay and Dr. Bassell over the years were on the books and records. There was no indication at all, and no evidence, and even no contention that there was any attempt for them to hide any of the information. It was there on the books of the records of the corporation at all times. And all stockholders and directors had access to the books and records pursuant to the bylaws. There's no evidence that at any time other than just before Dr. McKay was fired, they asked for the books and records, and it was given to them not at that moment. They came in, asked for the books and records. It was not given to them then. It was given to them the next morning. Other than that, there's no evidence for the years back to 1984 that any director asked for and was denied any access to the books and records. So what we have bottom line is that 2 years and 3 months before suit was filed in this case, the corporation had all of the pay records. The corporation had all the information. It was available to the directors. The record will reflect that. The corporation was controlled by the board of directors. And from December 12th of 2015, it was controlled by a majority of non-culpable directors. The directors testified, and in the testimony, they said that they had been unhappy with the way things were running for years prior to that. So they had the suspicion, they had the records, they had the authority, they had the information, but they basically stood on their hands. The trial court then been over.
Counsel, I've allowed you to exceed your limit a little bit, so I'd ask you just to come to a close.
Okay.
And then you'll still have, both of you still have your rebuttal.
What the trial court did was found excuses, not legal reasons, but excuses kind of at every turn to justify the actions by the corporate board in this case. Statute of limitations is not fluff. It must be strictly construed, and our position is that had the court strictly construed the statute and correctly construed the facts, evidence, there would have been a judgment as a matter of law at the close of the evidence after the trial. And we're asking this court to grant judgment as a matter of law. Thank you.
Thank you. Mr. McIntyre.
If it please the court, I am Jack McIntyre with Depew, Gillen, and Wichita, and I do represent MCAC.
I apologize for mispronouncing your name.
Oh, believe me, it happens all of the time.
Well,
the facts of this case have been gone over and over and over, and I'm sure the court has read all the briefs and everything, but it's salient to know that the jury saw all of the facts. There was no limitation on evidence put on anybody or anything. They saw everything. And at the conclusion of all of that, they found that McKay and Bassell, in violation of their fiduciary duty, had taken $3.5 million that they weren't entitled to. And that amount they took was neither fair, nor was it taken in good faith, and they held that they acted together. The jury found all of that with no limitation on the evidence before them. Now, the part of that that is probably the most important is that they found there was no disclosure. Every single theory the defendants espouse requires disclosure by them of their self-interested takings. You've got Sampson v. Hunt, Newton v. Hornblower, Scoletti, Freitag, all of the various cases put the burden on a fiduciary to disclose their self-interested deals. Probably the best said was in, I believe it was Freitag. One cannot take advantage of waiver, laches, estoppel, or the statute of limitation when his concealment was the cause for the delay. Every single thing in this case turns on disclosure. There could be no discovery without disclosure because Doctors McKay and Bassell withheld all of the information from anyone else.
Counsel, does it change that analysis in light of the fact that this is, whether that is reasonably ascertainable is an objective test? So at some point, can the directors just sit back and wait for disclosure, or do they have to seek out whether it's ascertainable?
No, they cannot, and they did not in this case. We need to understand the circumstances of this. Doctors McKay and Bassell withheld all access to the financial documents. Number one, they did not allow. Dr. George went in.
Counsel, if they withheld all information, what was the information Dr. Babish was receiving as early as 2014?
Dr. Babish received a PDF version of an abbreviated check register. It was not searchable. It was not combinable. It was not usable in any general format. She got, it was sent to her supposedly on a daily basis. She would get sometimes one a day, sometimes 5 in the end of the week. It would be the daily check register. They would have 30, 40, 50 entries. There was no indication on the check register what the payments were for. Dr. Bassell said, given that same check register, he would not be able to determine nor see that anything was wrong. He would not be able to determine how much the doctors were paid. Carolyn Holdman, the office manager, also in regard to that check register, said she could not determine it.
Council, did Dr. Babish have any obligation as secretary treasurer of the corporation once she received that information to ask for that additional information?
She and the other doctors did ask. I will give you an example of when Dr. George asked Dr. Bassell if he could see further information. Dr. Bassell yelled at him, told him he could not, and no other doctor could see this financial information. He reduced his salary to where it was the lowest in the company, and he gave him the worst assignment schedule for all of the doctors. That occurred before really all of this, the rest of this took place. The actual discovery took place at a meeting on August 12th of 2017. And that's a meeting where they were discussing the SurgiCare part of their operations and wondering if they should continue that. During the course of that meeting, Dr. McKay pulled out some financial statements. And those financial statements, when he did that, he inadvertently pulled out a spreadsheet that showed that something was going wrong, that the numbers made no sense, implied that he was doing something wrong. Well, that prompted Doctors George and Manry the next day to go ask for financial information. They went and asked Carolyn Holdman, the office manager and financial person in the company, to see the financial records. She was told no. I was told by Doctors Bassell and McKay, you can never see these records.
Council, I want to let's accept this factual finding that it appears that the district court made that there was no actual knowledge until August 2017. Even if we accept that, is that our test, or is it whether and when that knowledge was reasonably ascertainable to the directors of the corporation?
You must have some red flag before you have a duty to look. You must have some red flag that something is going wrong. And that did not occur until Dr. McKay inadvertently released this financial statement. Then when the doctors followed up on that, they were told they couldn't do it. McKay called him up and said, you know, you cannot look at the financial records of this company, called Dr. George, and said that. He then called Dr. Bassell and Dr. Babish, and told her that no one could see the financial records and no one could know how much any other doctor was being paid. Following that.
Counsel,
yes,
I have
ma'am.
a question. Isn't that inconsistent with Dr. Babish's statements? Didn't the red flag raised to her as early as 2015?
Oh, they were all uncomfortable with what Dr. Bassell said, referred to himself as a benevolent dictator. He ran everything totally. They were all uncomfortable with this. They were all shareholders. Honestly, they didn't know they were directors or not, because McKay would appoint them, Dr. Bassell would appoint them, McKay would sign the appropriate documents and file them, and that was it. No one knew they were directors.
Didn't they sign off as directors on a document in December of 2015?
They periodically signed documents that were put in front of them by Dr. Bassell and then Dr. McKay. For example, when the new bylaws were adopted, they were allowed to see only the signature page and were not allowed to see anything else. So they signed where they were told by the dictator of MCAC, Bassell, and it was followed by him as the dictator by McKay.
Counsel, these were very highly educated individuals who had a stake in this corporation, and your assertion to us, if I understand correctly, is they never read a single document. They simply attached their signature to it, unknowing what they were signing.
I'm sure they looked at some documents. They did not sign very many documents. Bassell just ruled with an iron fist, and so did McKay after Bassell retired. So they had very few documents in front of them. But I don't want us to digress too much from what's important. The control of the company is only an issue if you find that Bassell and McKay disclosed their self-interested transactions, which they did not. That is what is required in Sampson v. Hunt, Newton v. Hornblower, Chtd, and all that. It is practical management of the company, and that was Bassell and McKay. They controlled this company. And then it is the required disclosure they must make. I'm sorry, please go ahead.
Where does duty to disclose and reasonably ascertainable, those seem to take divergent roads. The statute says reasonably ascertainable. Where was the duty of these directors to take an active role in attempting to satisfy this level of discomfort that you reported they all had as early as 2015?
I don't agree.
Ascertainable to me indicates the duty was on those directors to attempt to acquire that information.
I don't agree with the statement that they were directors as of 2015, nor did the court below. They did not know they were directors. All they knew was that Bassell and McKay ran the company, and they worked there. Now, they were shareholders, and they supposedly were to be treated approximately equal. But they had no knowledge that they had the ability to go in and do things. They did not know they were directors. This never even came up in any serious format until the February of 16 meeting. And that was to talk about other stuff. And during the course of that meeting, they said, well, we are all like to be directors. And then after that meeting, the board of directors held another meeting and appointed the same 4 board of directors. There was never another directors meeting at which they participated. There was never an acceptance of directorship. There was never even an offer of this directorship to them after that. They did not act as directors. They did not know they're directors. This case is exactly in point with Sampson v. Hunt and Newton v. Hornblower. If they had the titles, they didn't even know them, and they worked there following the instructions of Bassell, whom they thought they had to follow.
Counsel, if they signed the document in December of 2015 saying that they were directors, why wouldn't they know they were directors? These are educated people.
You're referring to them as educated people, and they most certainly are in the medical field. And that, like our area of expertise, is a vocational field. They know how to be great doctors, and they are great doctors. But if you ask me to go do someone's anesthetic or take out an appendix, I wouldn't have any idea how to do it. Yes, they're educated people, and they're probably very, very smart. But that doesn't mean they have the understanding of corporate matters that your honors and I do from our practice and our years as lawyers.
And so do we allow them to impeach their own signatures by just saying, I didn't know what I was signing? I mean, is that something that we allow people to do when we have a written document and a written signature?
If you follow Sampson v. Hunt and Newton v. Hornblower, you most certainly do. You most certainly allow them, if stuff is put in front of them and told to sign, and if they're not actually running the company, you most certainly do. Now, McKay asks us in his reply brief, he says, we believe that 6513 parent d parent overrules Newton v. Hornblower and Sampson v. Hunt and Chtd and that whole line of cases. Says it changes the common law and overrules all of that section of common law. Well, there was no indication when that statute was adopted to ever overrule that area of law. The question is, were McKay and Bassell in control of the company? And they were. That is not even an issue. Now, the only red flag that occurred
was not an active participant after 2015. Is that correct?
I did not hear you, ma'am.
Dr. Bassell was no longer actively involved in the practice after December 2015. Is that correct?
That is correct, except for the fact that Dr. McKay continued to hide the actions that Dr. Bassell had performed before that date. They had worked together before that date, and then after that date, McKay, essentially on his own, continued to hide and proceed in the same way with taking additional money for himself.
But Dr. McKay was a minority director after December of 2015. The remaining directors would have been considered non-culpable directors. Is that correct?
The remaining directors after that date, some were retired, but the others were not involved in the misappropriations. However, they also had nothing to do with running the company.
Wasn't Dr. Babish secretary treasurer at that point?
Babish, she may have had the title secretary treasurer. She was told she could not see the financials. Dr. Babish and Dr. McKay did not let her see the financials. They told her that even she couldn't know the compensation of the other doctors. Matter of fact, they told, as I mentioned in the brief, Dr. Bassell said you would be fired if you asked for the compensation of the other directors.
Counsel, is that a red flag?
Doctors,
Is that a red flag if that, if you're Dr. Babish and the president of the corporation tells you you cannot see this information, does that put you on notice that there's perhaps something untoward going on?
Well, he also did it in the context of also saying all of us make about the same. I get a little bit more because I'm acting as an administrator, and McKay gets a little bit more acting as an administrator. And they actually gave Babish a very small sum for having the title of treasurer. So no, in that context, it is not a red flag. The red flag came when they actually, for the first time ever, saw a financial statement that did any form of disclosure, and that was by McKay in the meeting on February 12, 2017, and this lawsuit was filed within 7 months thereafter. You had that, you then had you then had Dr. George and Dr. Manry and Dr. Cleveland really fighting to get the financials because they'd seen something was wrong, and in doing that, they discovered that McKay had made a loan to himself, which he had started to repay and never finished repaying. And at that point, they knew something was wrong. They hired an auditor. The auditor came in. It was the very first time when they got the audit report that they knew they knew Bassell had done anything wrong. And it followed that not only had McKay taken the $100,000 he shouldn't have taken, but he had taken other substantial sums of money.
Counsel, on that 100,000, I've got two questions. One, you say that Dr. Babish was paid a small sum to be treasurer. If I understand the record correctly, that's $25,000 for the year.
I was thinking it was 10,000, but there is a sum. Yes, sir.
All right. And then on the $100,000 that Dr. McKay took, wasn't that on the advice of the CPA for tax purposes to avoid tax-related issues and complications from the corporation by him taking a prepayment of his salary as president?
Well, there's two problems with that. Number one, that statement is factually not correct. I mean, that is not the right tax analysis, but this is an area where I work, so I apologize if I go into that too much. But secondarily, let's assume that he took that out as a loan, so there wouldn't be cash in there, and he promises to pay that on a monthly basis, and he makes 3 or 4 payments, and then he does not make any more payments. So, okay, if you want to go on that argument, he misappropriated $60,000 to $70,000 instead of the entire $100,000, even if you buy his statements on that. And he did not pay back any of that money until we forced it with the lawsuit.
All right.
Counsel, I have another quick question for you.
Yes, ma'am.
So you have stated to us that the other individuals became what you classified as uncomfortable in 2015, or at least early 2016.
No, 2017, Your Honor, 2017.
No, that's when you said that they knew something was wrong, but previously you had said they became uncomfortable in 2015. So my question is, in that 2-year period, was this information not reasonably ascertainable, given the fact that they were able to hire an auditor and go back and find or confirm what their suspicions were? How is that not reasonably ascertainable in accordance with the statute?
Your Honor, I don't believe I said they became uncomfortable in 2015. If I did, I totally misspoke. They, in the only sense that they were uncomfortable, they hated Dr. Bassell's dictatorial style of not allowing them to see anything, and then similarly with McKay when he refused to. What happened in 2017 was the first time they ever had a red flag that something was wrong in the financials. And that's because of McKay's accidental disclosure during that meeting. And it didn't say he did anything wrong in that accidental disclosure. It just was enough wrong in the numbers that it caused them to wonder. And then when they went back in to look, the first time they ever had the red flag, when they wanted to look for something, McKay blocked it. Carolyn Holman.
Counsel, I want to ask you a few questions that I asked your opposing counsel, just so I make sure that we're all on the same page. Do you agree that this reasonably ascertainable test is an objective test?
I think the reasonably ascertainable test is a test that is based upon finding a red flag. You then have a duty to check further. So to the extent a red flag exists, it is a subjective test. And I think it is subjective in the sense if there is some disclosure, you can follow it. In this case,
and counsel, what's your legal basis for that, other than it just that you feel in your experience that's the way it should be? What is there a case that says that it is a subjective test?
Well, when I say subjective test, I'm referring to it requires a factual analysis. In this case, it does not require a financial analysis because there was no disclosure. If McKay and Bassell had disclosed financials, if they had let the doctors see the financials, if they had let them see what other doctors were making, if they had
Counsel, I just want to try to figure out. So if it is an objective test, or if it is a combination of an objective and a subjective test, who makes the determination as to whether it is reasonably ascertainable? Is that something the court makes, or is that something that the jury makes?
If in fact there were sufficient evidence to demonstrate that the doctors McKay and Bassell had furnished some evidence that they were stealing the money, that they were misappropriating the money, anything to imply that, then yes, it would be a jury question. But that's not the situation. They withheld all financial data from a doctor except his own compensation. They weren't allowed to see the profits or losses of the company. They were not allowed to see anything until finally, after they got through the hurdles in August of 2017, the lawyer for MCAC told McKay, okay, you have to let him see him. Even at that point, when they went and saw the records, Carolyn Holman, the office manager, and the person who did see the financial records told them, I'm sorry, I've been told this whole time to hide them from you. Now, that is the situation. The doctors had that. There was never an opportunity for them to discover anything because there was zero disclosure. And the only thing they ever gave anyone were the useless records they gave Kim Babish. Even she couldn't see those. And by the way, at the same time, Kim Babish was given these useful records. McKay and Bassell were given full, regular financial statements. And probably the single most important thing is they were regularly given a financial statement that said exactly how much each of the doctors was making. It was prepared specifically for them, yet they shared that with no one, nor allowed anyone to see it, even Kim Babish, who they'd given the title treasurer. I think that we've covered a number of things. I'm not sure what point at which to go back. I would tell you that the arguments they raised in their briefs, their replies and all that, ratification, waiver, estoppel, and all that kind of stuff, again, they all required the disclosure because they require you to know something before you can ratify it or waive it or estoppel it. I wanted to mention that one thing about, or two things actually, about the reply briefs. I mentioned previously that about the Dr. Bassell threatening to fire the doctors. There was 7 citations for that to the record. They challenge 1 and say that taints everything. The other 6 are absolutely exactly right, and the 1 is partially right. They say that in the reply brief that Idstrom versus Alliance, which talks about conspiracy, that nowhere in the brief does it cite the elements of conspiracy nor talk about the facts. The elements are quoted verbatim lengthily on page 9 of that case, and the facts are discussed on pages 8 and 9, determining their applicability. They say that the entire case was tainted because the word misappropriation was used in the court's instructions. And it was the first time it was used once before the trial. It was used in the petition, in the amended petition, in the answers, in the pretrial order. It was used 50 times before we got to trial. Jay Fowler put it in his
I locked out. Well, I guess we'll pause a second and see if he comes back on. All right, now we've lost him. James, can you see if you can pick him back up? Mr. McIntyre? James has said he'll let him in once he reappears in the waiting room, so he has not done so yet. Technology is great, but can be frustrating.
I don't know what happened on that. If it was at our end, I do apologize.
Well, you were, I think, in the process of doing your summation when you cut out, so I'll let you proceed. Nope, he froze again.
There we go. I can hear somebody.
All right.
There, I think something's working now. I don't know what it was, but I seem to be back.
Yes, sir, you can proceed with your summation. I think that's where you were about to start when you cut off.
Thank you, Your Honor. As I mentioned before, every single thing in this case turns on the issue of discovery, whether it's the primary issues that were actually went to the jury or those in the directed verdict. The Idrum versus May case holds that those would be harmless error if there was no discovery. And every bit of discovery in this case requires upon disclosure. Newton v. Hornblower, Sampson Hunt, Chtd, every one of those puts the requirement on these directors to have come forward, Dr. McKay and Bassell to have come forward. The jury saw all of the evidence anyone wanted to present it, and it determined that they did not come forward, that there had been no disclosure. They determined that Dr. McKay and Dr. Bassell took more than $2 million, Dr. McKay, more than $1 million, excuse me, I said that backwards, $2 million, Dr. Bassell, $1 million, Dr. McKay, and they did it not in good faith, and it was not fair, and they held that they did it together.
Well, counsel, wasn't that figure based upon the accountant using the lowest paid doctor's salary in comparison to Dr. Bassell and Dr. McKay?
The amount of the money was not challenged in court, Your Honor. The damages were not challenged. They were found by the jury. The fact Dr. Jay raised it here, it surprised me a little bit. That nor were the amounts, of course, appealed from. The auditor who determined these amounts also discounted for really convenience, and I think this is one of the reasons that way was approached. He did not include all of the other ancillary payments that Dr. Bassell and Dr. McKay paid to themselves. For example, Dr. Bassell would take trips around the world for various reasons, and the entire cost of that trip would be plugged into MCAC. That was also not included in the calculation of damages. It was a convenience factor that was accepted at court without significant challenge.
All right, thank you.
Thank you
Mr.
very much.
Fowler?
Thank you, Your Honors.
Your Honor, the damages were challenged at trial. We had an expert witness who assessed the relative reasonableness of compensation. We challenged the methodology used to calculate the damages.
Counsel, but the jury found that against you, right? And you didn't appeal that issue.
Well, we appealed the judgment, and I think we did appeal and we briefed the issue. We pointed out in our briefing that we felt that the calculation was improper. So I think we did appeal it. And we made not only a motion for judgment or for a directed verdict, but a motion for judgment at the end of the evidence on that issue as well. But I just have a few minutes here, so I want to go back and address one particular point.
Counsel, before you do that, I have one quick question for you, and that is, can the active concealment of records toll the statute of limitations?
The active concealment of something can toll the limitations in certain periods, but the reasonably ascertainable test still applies. And that's the key here. And we have a record. Fortunately, this court is going to review the entire record. And what you will find is that when all of these doctors were deposed, they made material significant admissions of their state of knowledge about the nature of the compensation. That was then part of the summary judgment proceedings in this case. We talk about what Dr. Babish knew or didn't know. If you go to the record, volume 3, starting at page 372, that's the part of the briefing that's citing a statement of uncontradicted first. By August 20, 2014, you knew Dr. Bassell's salary was substantially higher than yours. Yes. And you knew his salary was substantially higher than all of the other doctors. And by that date, you had the ability to make the calculation of the salaries of all of the other physicians. And you knew the total amount of compensation of doctors from the financial statements you got, and you could have calculated the average. All of that is in the record as of 2014. I differ with Mr. McAteer about what Dr. Babish got. There's a stack of exhibits. And if you go and you look at that stack of exhibits that are part of the record, and you look at the attachments, you can see that Excel spreadsheets were actually attached. Searchable documents were given to her. And then, and perhaps more significantly for the limitations purposes, as it relates to February 16, 2016, she was asked and she admitted all of the information that is disclosed in these exhibits related to financial payments to Dr. Bassell and McKay were known to you as a member of the board of directors and has offered the company by February 16, 2016. True? Answer, true. That's what the evidence is in this case. The red flag, if you need a red flag, existed from the early years because they were dissatisfied with Dr. Bassell's methodology, but they always had the right to vote him out of office. Dr. Bassell did not have voting control of this corporation. They allowed this process to consider because it was continue because it was to their mutual advantage. It's only an after the fact reconstruction of the circumstances and the facts that they come up with this claim that they presented to the jury. We dug into that. We provided the evidence to the court. The evidence was uncontroverted. And one final point. There's a notion at times that the court can't rule on a motion for summary judgments that's denied once a case goes to trial. Well, the Evergreen case, this Court of Appeals decided, says that if you file your motion for directed verdict, and then you file a motion for a judgment, the court is entitled to go back and assess that summary judgment issue. And so I urge the court to go back and look at the summary judgment record. And when you do so, you will see the uncontroverted admitted facts require entry of judgment on the statute of limitations. That's regardless of whether or not Dr. Babish is entitled to change yes and absolutely answers to no. You should also find that that's not permitted under Kansas law. This court should enter judgment. Thank you.
Thank you, counsel. That will
Thank you,
conclude
Your
our
Honor.
argument. That'll conclude our argument here this morning. We'll take the matter under advisement and issue an opinion as quickly as time allows. Have a great day.